Having a wonderful morning. Hello, it's Josh Goldstein here, coming at you with immigration news, information, and inspiration. Today's topic is how to speed up the processing for your I-130. Now, why would this be important to you? I'm going to get into all that, and I'm going to get into what the solutions are. But before I do that, I want to introduce myself. If you don't know me, my name is Josh Goldstein, and I'm the founder and CEO of Goldstein Immigration Lawyers, a law firm that helps people reach their immigration goals. We have offices here in Los Angeles, where I live, and also on the East Coast in Boston. We're opening new locations in 2024, and we help people around the world, across the country, everywhere, reach their immigration goals. There's no bigger obstacle to reaching your goals than the absurd processing times that are plaguing the immigration system at every level. Now, let's talk about the I-130 visa petition. So, if you want a petition for your family member, your mother, your father, your children, your brothers and sisters, your spouse, if you want to petition for them, you have to file a visa petition, the I-130. Now, when you file the I-130, you have to wait for that to be approved as the first step in the application process. But as you know, if you've looked into this, the processing times are absolutely ridiculous. They're absurd. And what can you do about that? Well, there's a few things that you have to keep in mind. First of all, there is one set of absurd processing delays that are related to the visa bulletin itself. Now, what do I mean by that? Well, if you're petitioning, for example, for your brother, and you're a U.S. citizen, and your brother lives in the Philippines, that's going to take close to 30 years. 30 years. It's crazy. Now, unfortunately, that's just the way Congress set up the system. It's set up by design to make you wait and wait and wait. So if you're waiting each month for a sibling petition, you have to check the visa bulletin to see where you are in line. Each month, the Department of State on its website publishes a visa bulletin. And on its visa bulletin, it will tell you which cases it's processing. And that will give you an approximate feel for how long it's going to take to get your case approved. If the delay in your case is related to the visa bulletin, then there's nothing that you can do except to wait. And it's very, very unfortunate. But that's the truth. Now, we have a good question that's relevant. I'm going to be answering your questions. And by the way, I'm live now on TikTok, LinkedIn, Instagram, YouTube, of course, Twitter or X. I'm live on Facebook, and we have a Facebook group with over 15,000 members that is dedicated to talking about visa delay situations, 221G, and so on. Now, I've got a great question from YouTube that comes from one of our friends named Linda, with a Y. And Linda says, what about the spouse of an F2A? The spouse of an F2A, what does that mean? That means that you petitioned for your husband or wife, and you are a permanent resident. You're not a U.S. citizen. If that's the case, then you have to wait and see when the visa bulletin is going to be current. The other thing you can do is you can become a U.S. citizen, and then you don't have to go through the visa bulletin process. But right now, I'm going online. I'm checking the visa bulletin for December. F2A, they're currently working on cases that were filed in February of 2019. So that's what, a 3-year, 4-year delay? Excuse me. So it's very, very long. Now, if you come from China, Mexico, the Philippines, or India, then you have to go in a separate category where they make you wait even longer. And this is the visa bulletin. This is how it operates. This is the way it works. I think when I explain it to people, I always say, listen, if what I'm telling you makes no sense, then you probably understand what's going on, because the visa bulletin doesn't make a lot of sense. So one set of delays is related to the visa bulletin. Okay. Now we have a second set of delays that has nothing to do with the visa bulletin. That's just related to how absurd the immigration process is right now. What the hell is going on and what to do is a question from Yusuf from Facebook. And I think that that's exactly how I feel about that. What's the website to see the visa bulletin? Well, if you Google December 2023 visa bulletin, you'll go to a website that ends in .gov. And I can put it up here. I will put it up in the chat. You can't click on it, I guess, but I'll put it on YouTube right now. And let's see if I can show it here. That's the website for the visa bulletin. And sometimes people who've been waiting a really long time ask me if there's anything that can be done about the visa bulletin delays. Can you do a lawsuit to help make the visa bulletin go faster? And the answer is no. There's nothing that can be done. Now, Linda says, so you say 3 years means 2026? Well, it gets even more complicated, Linda, because when you have the visa bulletin, you cannot accurately predict when it will become current because it does not progress in a linear fashion. This month, that category was working on cases from February 2019. So next month, we don't know what it's going to be. It could suddenly become current, or it could be stuck in the same visa bulletin situation as it is now, or God forbid, we could be in a situation like we were with the August 2023 visa bulletin, where it retrogressed and it went backwards. So when Linda asks whether it might take 3 more years for the F2A category to become current for her priority date, the answer is maybe. Maybe it could. I really don't know. But you have to watch it each month, and you have to avoid thinking about it as a logical progression. So let's talk about cases that are delayed, not because of the visa bulletin, but for other reasons. So if you file an I-130 and then 2 years go by and USCIS has not made a decision on the I-130, and that I-130 is an immediate relative petition. It's for your mother, your father, your minor children, your husband, your wife. If that's the case, then what possible explanation is it for why the I-130 would continue to be delayed? Why would that be? It doesn't make any sense. That's crazy. If that's the case, then you have a few options. Now, the first few options are ones I'm going to run through. They're things that I don't. Rosanna says, are you statewide? Yes, I am. I am statewide. I can help you wherever you are. This is a question that came to us from TikTok. Now, here's a question from Yusuf. He says, let's see if I can find the question. Every time I expedite, they didn't respond. So one of the things you could do is you could file a request to expedite your case. And there's no reason not to do that. You can do it. It's free. It's easy to do. But the problem with the expedite request is it doesn't really work. So that is one of the problems. But you can try. You can try to do that. You can also, you can call USCIS. You can write letters. You can contact a congressman. You can do all these sorts of things. The problem is that they don't effectively resolve the delay in the processing of your immigration case. So if you've tried to call USCIS, you've tried to contact a congressman or senator, you've filed expedite requests, you've done all those sorts of things, and waiting just doesn't seem to get you anywhere, then you're ready to take action. And that's where my team can help. What we do is we go to court and we file a lawsuit called a writ of mandamus lawsuit. We file a lawsuit against USCIS. And the basis of the lawsuit is that the delay in the processing of your case has been unreasonable. And the definition of unreasonable is a little bit of a gray area, and there is debate about what sorts of delays are reasonable and what sorts of delays are not reasonable. But nevertheless, we have criteria that we use to determine that. And if your case is stuck for whatever reason, and you just don't want to wait anymore and you can't wait anymore, then we can help you file a lawsuit to challenge the delay in the processing of your case. Now, it says here, can I speed up the processing time for your I-130? The answer to the title of this video is no, you can't speed up the processing time. But you do have the right to have your case processed within a reasonable period of time. Every case should be processed within a reasonable period of time. And when USCIS doesn't do that, then you have the right to go to court and demand a response. And you can ask the question that our friend on Facebook has asked, use oaf, what the hell is going on? And why are you not responding to me? We've had cases, listen to this, this is incredible. We've had cases where USCIS will come back to us and say that the reason that they can't process the case is that they've lost the file. So it's possible that the reason that your case is stuck is that USCIS is negligent, completely negligent, and they're not doing their jobs. A lawsuit is one of the only tools that you have at your disposal to make sure that your case is processed in a reasonable period of time. So that's what I have to say. And one of the sayings that I always have on this channel that I always tell people is waiting leads to more waiting. It doesn't get your problem solved. I'm going to be taking questions. So if you have questions about any of this, I want you to put your questions in the comments below. And I'm going to do my best to try to answer them and try to give you a good response, whatever your question is. We have Juana on YouTube. Can a permanent resident apply for U.S. citizenship if they have domestic violent record on his file? So that's a question that relates to naturalization. And when it comes to naturalization, anyone who applies for naturalization has to prove that they have met the good moral character requirement. And the good moral character requirement is for a period of 3 or 5 years leading up to the application's filing. And when you apply for naturalization, they're going to review your criminal history very carefully. And if you have any domestic violence incidents on your record, you have been arrested or charged or convicted of domestic violence, then that could be a bar to establishing good moral character. I hope that answers your question. So it's not really the domestic violence, but it would be criminal cases related to domestic violence. All right, let's head over to TikTok and answer some questions. How long is it going to take to get an EAD or work permit on a marriage-based case? I think it should come within 6 months of applying. That's my answer. Let's go over to Instagram and answer a question. This is from Nushimani. Nushimani, thank you for your question. It says, I got rejected by the U.S. Embassy because my master's was English literature and I was admitted to a second master's of creative writing. How can I justify that? Well, I don't know. I'm sorry that you got your visa denied. The consulate, there's something called the doctrine of consular non-reviewability. I have a lot of immigration laws that I don't like. There are a lot of immigration laws that I don't like. My list of least favorite immigration laws is a long one. And the doctrine of consular non-reviewability is one of my least favorite laws. It says that whatever crappy decisions that the consulates make, that you're stuck with it and there's nothing you can do. So I know that's frustrating. What other questions do you have? And also, why don't you put in the comments below, tell me where you're located. I'd be fascinated to hear this. I love when people are tuning in from Pakistan, the Middle East, Canada, all over the US. It's really gratifying to see where everyone's from. So I don't know about you, but I'm in downtown Los Angeles right now in my office. Where are you at? Let me know. Here's a question from Sarush Khan on Instagram. Can the I-130 and the I-601 be filed concurrently if the applicant has already received a non-immigrant visa refusal and was determined to be inadmissible at the time? Chicago, we have one. In order to really answer that question accurately, I would need more information to find out more about the details of the case. But I'm left to speculate as to what your scenario is. But if the person needing the waiver is outside the US, then you cannot file the I-601. My understanding is you cannot file the I-601 until you've had a consular interview, even if you've already been determined to be inadmissible. Nushimani is in Iran. This is fantastic. We have so many clients from the Persian community, and it's great to have you here. We also have a Telegram group that is dedicated to the Persian community, and it talks about visa delay cases and other issues that are very relevant for the Persian community. Najim Muznibi is in the Bay Area, San Francisco. Fantastic. We have someone in Sweden tuning in. This is fantastic. Good. I'm happy to be with you all, and I'm grateful that you spent some time with my content. Here we have a question on Instagram from It's About Cameron. I live in Sweden. My ESTA got canceled due to immigrant intent in 2022. I visited once in 2021. I have no bar. When can I reapply? That's a great question. The question should be, when should I reapply? Well, the reason that your ESTA was canceled is that they thought that you had the intent to immigrate. And so you should only reapply after you have waited a sufficient amount of time, when you can establish that you have deep ties to your home country of Sweden. That means that maybe you own a house or a real estate or an apartment or flat in Sweden. You have a car, you're in school, you have a job, you have a family, et cetera, et cetera. But you want to make sure that you can show that you're only coming for a short period of time and that you have a strong ties to your home country. And I would wait as long as you can. If you were denied in 2022, I would give it a couple of years, because getting denied for immigrant intent is kind of like stepping on a piece of dog shit. It gets stuck on your shoe and it stinks and it's hard to get off. And so it takes a really long time. And the longer you wait, the easier it will be to establish that you do not have immigrant intent. And I think it helps that you're from Sweden, because that's a country with a lot of economic status. And the more likely it is that your country, that you would go back to your home country. Whereas if you were from a poorer country, then it's harder for people. I hope that answer makes sense. My Telegram group is called Visas for Iranians. We have someone from Guyana who tuned in. Faye, thank you so much. Really happy to answer your questions. Let's go back to A question from YouTube. This is from Rudyard Utar. I applied to NVC from January 2023. My spouse is a U.S. citizen. I'm in Jamaica. She's living in Florida. My petition was approved in October 2023. Well, you're waiting, Rudyard. You're waiting for an interview. And that is very frustrating. There's no reason that it should take more than a year. And I think that you should consider a mandamus lawsuit, and you should contact us to evaluate that. But it doesn't make sense to me that you would have to continue waiting. Let's go to some more questions. Hang on. All right. Here's one from Mila on Facebook. I'm going to put the question up here. Mila says, "How are you, sir?" "I'm very well. Can I sponsor myself through my bank account? How much money should I keep for my sponsorship, knowing that my wife did not work for health reasons and I have 2 American children? My wife and children have lived in California for a long time. My category is F21. Thank you." Mila, can you sponsor yourself through your bank account? I think you're asking questions about the I-864 affidavit of support that's required for family-based cases. Typically, in most of the cases that we handle, the affidavit of support must be filed by the petitioner, by the visa petitioner. That would be, in this case, your wife. Even if your wife has not worked and does not meet the requirements, she still has to file an affidavit of support. Now, the question that you've asked, Mila, is could you sponsor yourself? And the answer is yes. After the I-864 is filed by the visa petitioner, your income can be used for sponsorship purposes, but only if you're working with legally with a work visa. So Mila, if you're on an H-1B visa, you have a job and you live with your spouse, there is a scenario where your income could be used. Most of the cases that we handle, the beneficiary's income cannot be used. So we would just have to take a look at it more carefully. Let's take some more questions from the crowd. What's going on? Here's one from Instagram from Idade Ragi. I filed my I-130 for my siblings 13 years ago. Good job. But haven't heard from immigration. The wait time for Iranians is 13 years. How can I get their files going? Thanks. Well, the question that I have for you is your priority date current? If your priority date is current, then USCIS should send your file to the National Visa Center. They should ask you for more fees and more forms and more documents. And then at that point, they should set up an interview and finish processing your case. So there are things that should happen. And if those things do not happen, then you should begin to call and inquire and figure out what's happening and try and get things moving. And if that doesn't work, then our firm can assist you by filing a mandamus lawsuit. I hope that helps. Here's a good question from LinkedIn from Zabi Nouri. Any update regarding the Islamabad delay for Afghans waiting for interviews? We have so many clients from Afghanistan and Pakistan who are waiting for interviews in Islamabad, and there just seems to be no end in sight for the types of delays that people are facing. It's incredibly, incredibly frustrating. And I don't know what to say, except if you haven't had an answer, then this is something that my team can assist you with. So here's another question from TikTok. This is from Max. It says, "Hi, sir. I applied for my B1, B2 visitor visa. Can my nickname on social media affect my application?" Um, that's a good question. So, immigration does review social media, and there are applicants who have to file a DS 5535, which means you have to disclose all of your social media handles and all your names. And if your name was Death to America, then that would probably hurt your chances of getting a visa. But your name is Max, so I don't know. But I think you should be very careful about um, what you post on social media, and you should know that immigration will be reviewing it very carefully. Um, Steven Stanek post some questions. He's in Chicago. She's in England. Stephen, I remember you from a few weeks ago, and I think you had some great questions. Let me get to them here. Let's see. Can the embassy order rehab even after an I-601 waiver has been approved? My fiance was refused her K-1 visa for half a gram of cannabis possession nearly 15 years ago. Stephen, my heart goes out to you because I think that the immigration laws and the way that immigration handles marijuana is complete bullshit. It's so unfair. It's so unreasonable. It's absurd, totally absurd. All of immigration is absurd, but especially the laws that relate to marijuana use and possession. But if your I-601 waiver is approved, you may still have to go through a rehabilitation process. And the logic, if you follow me, is that someone who used cannabis 15 years ago is a drug addict. It's completely absurd, but you have to jump through all those hoops in order to get your case approved, and make sure that you have a really good lawyer, Stephen. And if you don't, we'd love to help you, but you do have to jump through those hoops and go through the rehabilitation process. Um, uh, it's completely nuts. Here's a question on YouTube from Adil Qureshi. My F1 student visa is an administrative processing since May of 2023 in Islamabad. What can cause these delays nowadays at the embassy? Well, we talked about the situation in Islamabad. They have trouble scheduling interviews. Okay. Now, Adil, you don't have a problem getting an interview scheduled. You already had an interview. That's what administrative processing is. And if you've already had an interview, then you know that scheduling the interview is not the problem. Now, why would there be a delay related to your case if they've already had the interview? Well, what they do to people from Pakistan and many other countries, especially majority Muslim countries, is that they make you go through what's called extreme vetting. You fill out a form called DS 5535, and they ask for a lot more information, and then they make you wait and wait and wait and wait. And whether they're checking anything, I don't know. But the delay of processing a visa that's stuck in administrative processing is something that my firm is dedicated to challenging. We fight these delays, and we do it all the time, and we have great results. Many of our clients are in Pakistan, and if you're sick of waiting for your student visa and maybe you're at risk of losing your scholarship and time is just wasting, then we would love to help you. We would love to help you. I'm going to answer a few questions that people sent me over the past week that I've been collecting, questions that I thought were pretty good. Here's one question. Has anyone ever gotten a denial on an immigrant visa? I understand refusal can mean that it's still pending, but when it's completely denied, what does the status show? That's a great question. The word denied never appears in this context. They only use the word refused. And the word refused has two meanings. One is that it means denied, and the other is that it means that your case is pending after an interview has been complete. So when they say the word refused, no one knows exactly what that is. We don't know whether it's refused means denied or refused means pending. It's crazy. Here's another question. If parents who are permanent residents of the U.S. take the reentry permit and leave their 16-year-old son here with a relative, making them his legal guardian, this will affect the son's permanent residence in any way? And the answer is no. As a permanent resident, you have to live physically. You have to live exclusively physically in the U.S. And as long as you do that, you're good to go. If you live in the U.S., you're fine. If you get your green card and then you go and you return to your home country, you're going to have a lot of problems. People run into that all the time. So keep your questions coming. Keep your questions coming. In the meantime, I am getting super excited for the holidays. Tomorrow is the first night of Hanukkah. My family and I are having a big celebration. We're getting excited. And we also celebrate Christmas. So we're going to go to Disneyland on Christmas. This is fantastic. We're getting very, very excited about that. My son asked me, he said, Daddy, this year, I want the best presents to come first. Can we do that? Can we have the best presents first? Why would you want to delay gratification if you're a child? No, you wouldn't. I thought it was hilarious, but no, we're not getting the best presents first. We're getting the best presents last. That'll be the grand finale. Here we have Vostal on Instagram. Hello, Josh. We already filed mandamus through your firm for my sister. That's great. The consulate has asked for 3 extensions already. Do you know how many more extensions are personally they can ask for? Well, Vatsal, thank you for being a client. I don't want to talk about the details of your case publicly because I want to keep your case information confidential. But I'll just talk in general about the mandamus process and the way extensions work. So getting 3 extensions in a mandamus case is really disappointing because what happens is you file the case, and then at the end of 60 days after you file it, they can either answer the lawsuit, which they never do. They can file a motion to dismiss, or they can file a request for an extension. And the extension seems like the exact opposite of what you want, because you want to get your case processed right away, and they're asking for a delay. So it seems like it's kind of like goes against the nature of the mandamus lawsuit. However, we agree to the extensions for 2 reasons. One is as a professional courtesy. And the second is because it usually means that there's been some positive movement in your case. So they could ask for an unlimited number of extensions, but typically we do so for strategic purposes. We'll agree to this. I hope that makes sense. And you should, if you have specific questions about your case, send an email to team@jgoldlaw.com and we can give you a better answer about what's happening in your case. But I guess what I would say is don't get discouraged. Trust the process is something that we say to clients who get down. Keep in mind that a sibling petition takes decades. So if it takes another 30 days, it's frustrating, but it may be worth it. Here's a question from TikTok. This comes from Carrie19. After rehab program and remission, do I still need an I-130? So I think this question relates to drug use in the immigration context. And I think in order to answer that, I really would need more information. I would need more information. Okay, so here's a question from Groovy Droovy on Instagram. It says, how long does DACA how long does DACA last, and how often do you renew it? So my understanding is that DACA is good for 2 years, and so you have to renew it every 2 years. Now, when it comes to DACA, I should point out that we have an election coming up next year, as you know, and one of the candidates is a Republican, Donald Trump. And Donald Trump, if elected, is very likely to terminate the DACA program. And last time he terminated the DACA program, the Supreme Court stepped in and blocked that. But the Supreme Court is different now. It's got more judges who were appointed by Donald Trump. So if you're hoping that the Supreme Court will block Trump's actions next term, then you're wrong. You're wrong. So I think you should renew your DACA right away. All right, getting a little more caffeine in my system. I'm getting a little more caffeine in my system. So if anyone has a question, ask me, and I'll do my best to answer you. Max says, if visa inspectors check my social media, must it be public or can I still have my IG private, sir? Well, what happens is on your DS 5535, they ask you to disclose all your social media handles, your names. So if you have one that's private, in order to accurately respond to your DS 5535, you'd have to disclose that. So I think you should be careful about what you post online. Eddie Dada Ragi says, thanks for replying to my question. Immigration is working on 2007 files. Mine's from 2010. Is there a way to expedite it? If yes, how? If no, what should I do? Does your office, can it expedite it? So if the visa bulletin says that they're working on cases from 2010, from 2007, and you filed in 2010, then you have roughly maybe 3 years to go before you get into the point where your priority date is current. And there's not a damn thing that I can do or anyone can do to help you out. So you just have to wait. And that's terrible. All right. Let's see here. What other questions do you have? Any of our friends on YouTube have questions? We have tremendous videos coming out on YouTube. This is super exciting. Let's see here. All right. Here's a question from Charmaine Johnson. She says, hi, Mr. Goldstein. I'm a U.S. citizen. I lost my husband 6 months ago. Very sorry to hear about that. I'm sorry for your loss. It says, and I wish to sponsor my brother and his wife to come and live with me since I live alone. Is there a way to get them here without waiting for years? And that was from a live video that we did recently. And the answer is that anytime you go through an immigration process, there is an application process and a waiting period. And if you're trying to sponsor your brother, I call that the retirement visa because it's going to take so long that it's effectively like having the ability to retire in the US. It may take 10 years, 15 years, 8 years, something like that. And then the question you have is there a way to round that? And the answer is unfortunately no. I'm sorry there isn't. I wish there were, but there isn't. Let's see what other questions we have. Here's another question from Instagram. It says here, I don't quite see this. Here's one. Joe Cuto Mwamu. I remember your questions from last week, and I want to thank you for joining us again. So she says, my husband does not have good credit, and we don't have a joint bank account. Will that affect the interview? Well, I don't know exactly what type of case you have, but first of all, I have good news. The immigration process does not look at your credit score. They don't care. They don't care. What they do care about in certain types of cases is whether you have a genuine marriage relationship. Is your marriage legit? Is it genuine? Is it? And a joint bank account is one of the many, many things that you can do to show that your marriage relationship is genuine. You don't have to have a joint bank account, but if you have a marriage-based case, you probably should. So, I don't know why you wouldn't have one, but you should consider figuring this out. Here we have someone says, where are you located? I'm in Los Angeles. We also have an office on the East Coast in Boston. And we are going to be revealing the location of our new office very soon. It'll probably be in January of 2024. And I'm excited about that. But we handle cases all over the country and around the world. So no matter where you're located, our firm can help you. There's a link on our website. Our website is www.jgoldlaw. We have tons of clients in Ohio, for example. We don't have an office yet in Ohio, but we have tons of clients in Ohio. www.jgoldlaw.com. If you go to that website, you will be able to schedule a free case evaluation with our team after you answer a few questions. And I hope that helps. Let me know what other questions you have. Let me know, folks. I'm very eager to find out what you want to know. Facebook user, he says, hi, I'm Darab. Darab, welcome, welcome, welcome. I'm glad you joined us. Let me know what questions you have. Max says, having a European nationality as Sweden, does it increase the approval rate of a B1, B2 visa? Yes, it does. Yes, it does. If you were from an extremely poor country, then I think it would be harder to prove that you're likely to return to your home country. This is not my personal judgment. This is my experience professionally. So I hope that helps. Let's see here.